call will be recorded. The informational portion will be recorded, but we will stop the recording before the discussion section. Okay, so tonight we're going to be talking about the recent attacks on Section 504. So we will be, the focus of this call is to talk about the case of Texas v. Kennedy, in which 17 states are suing the United States Department of Health and Human Services and trying to strike down Section 504. This is a law that is extremely important for us as disabled Americans. Here to talk about what exactly Section 504 is Mr. Sonho Steele Lachard, who is the Legal Programs Coordinator for the NFB.
All right, thank you for that introduction. Thank you as well for holding the call this evening. I was very grateful to hear that NABS was going to be educating our members and future members about exactly what this law is and exactly what this lawsuit is all about. So for those of you who do not know, Section 504 is in many ways the backbone of disability rights laws in the United States. There are some laws that don't intersect with 504, but they're pretty rare. Really and truly, Section 504 informs virtually all other disability rights laws here in the United States. Section 504 is one of the most sweeping sections of the Rehabilitation Act of 1973, which itself is a law that, in essence, says that disabled Americans cannot be discriminated against on the basis of their disabilities. It does actually go a little bit further. It says that nobody in the United States can be discriminated against on the basis of their disabilities. That is especially important for people who are here as tourists or who might be here on student visas or something like that. Anybody on American soil ought not be discriminated against by the government in its activities, programs, and services based upon their disabilities. The Rehab Act itself only informs directly under the law vocational rehabilitation and a few other programs and services in terms of its funding. However, the way that judges have interpreted Section 504 over the years would be that any public program activity service for the federal government or the state government is to either be made accessible or to be offered reasonable accommodation and effective communication. That's a really wide sweeping, hard hitting law. That means education. That means, in many cases, immigration, vocational rehabilitation, any communication you get from these government offices, any program, activity, or service that they offer the general public, they also should be offering to you. They should be making accessible to you and giving you reasonable accommodations. I understand that there may be questions about that. I'm certainly happy to answer them. Are there any questions for me about the sweeping nature of Section 504?
We are actually going to hold off questions till the end, I think so. Thank you so much, Mr. Steele Lachard, for explaining just how essential and just how important Section 504 is. Now that we know what exactly this law is and how important it is to us as disabled Americans, it is my honor to introduce the chair of the Advocacy Committee, Ms. Kaylee Brendel, who's going to talk to us a bit more about the current attacks on Section 504.
All right. Good evening, everyone. Very grateful to be here. As also said, my name is Kaylee Brundle, and I am very grateful to serve as the chair of the NABS Advocacy Committee and also to serve on the board of the National Association of Blind Students. I would very much like to extend my gratitude to Sanjos de la Chard for presenting to us this evening about the significance of Section 504 and its sweeping implications for disability rights, and how it is very much the foundation of disability law in this country and its importance there. So now that we know what Section 504 is, I'm going to explain the current threat against it, which comes in the force of a case called Texas v. Kennedy. You may also be referred to as Texas v. Becerra. That was its original name. In September of 2024, 17 states, and for a full list of those states, stay tuned for the resource section of this call. Those 17 states filed suit against the United States Department of Health and Human Services, and they claimed that Section 504 is unconstitutional. They sought to strike this entire statute down. And in February, there was an update to this case. So the Department of Health and Human Services, which is the defendant in this case, filed a brief alongside the 17 states in which we found out that both parties agree that this crucial disability law needs to be completely struck down. So the plaintiff in this case, which is the 17 states, and the defendant in this case, which is a federal department, the Department of Health and Human Services, both agree that Section 504 is unconstitutional and that it needs to go. So the fate of this law is completely in the hands of one Texas district court judge at this level of litigation. So when I first heard about this case, I was very curious to see what the justification could be for why Section 504 was unconstitutional. And so the complaint clarifies that the issue they have pertains to the spendings clause of the Constitution, which essentially, gives Congress the authority to delegate federal funds to critical aspects of and sectors of society. And there is a sentence of 504 that has kind of become very famous, right? This idea that any program or entity that receives federal funding cannot discriminate on the basis of disability. That is the sentence that these 17 states and now this federal department alleges violating the spendings clause of the Constitution. So what they're saying, right, is that Congress cannot restrict the use of federal funds like that. So, this law saying that we can't be discriminated against in this way, that's unnecessarily restrictive in their eyes. So that can have very broad implications because many other civil rights laws are worded in similar ways. This idea of any program or entity that receives federal funding or federal financial assistance can't discriminate on the basis of X, like that language, that statutory language is not uncommon. So that's a very damaging domino effect that we could potentially see. So in the complaint itself, and in the brief in February that was filed, we found out that there are 4 main issues that these entities take with 504. The first is the previous administration's decision to add gender dysphoria as a disability, which is consistent with a circuit court ruling that validates that. The kind of brief makes it seem as though that is the only issue that's being raised about 504. It's very important to point out that that is not the only issue that's being raised against 504, because if that was, right, they would be targeting that language and that language alone, not the entire law. But the entire law is under fire right now. And even though they're saying that we don't want to make this law unconstitutional, they have yet to amend the original complaint that they filed with the court right now. So even though they're saying to the media and they're saying in this new brief, we don't want to strike down 504, they have not changed that original language in the complaint they filed with the court that says that they in fact do. So that's problem number 1. Problem number 2 is where they want this protection against discrimination to apply. They really want to limit the scope of where it applies, and some of the sectors where it would no longer apply are education and healthcare. So 504 plans, they benefit millions of children. across this country with ADHD or with autism or with other learning disabilities. 504 plans serve so many people. So, and we all need those accommodations in educational settings, and we all have the right for hospitals not to deny us treatment based on our disability. So making sure that we have that protection in those two sectors is so important, and this lawsuit puts that in jeopardy. The third aspect is this mandate that services be provided in the most integrated setting. That doesn't mean anything more than we just need to be provided our services in the community. We can't be segregated. And unfortunately, as you're going to hear later in the call, segregation of disabled people, and specifically disabled children, is something that some municipalities are already facing. But thankfully, Section 504 provides a legal arm for redress. We don't really know what would happen if that legal arm were to disappear. So, segregation is a genuine fear if integration is gone. And, this complaint kind of makes it seem as though this integration mandate was a recent update. This has been here since the 1970s. This is nothing new. The last portion is the protection of disabled people against being placed in institutions. This may seem like it's something that, was just from the past and it's not something we have to worry about anymore. But dozens of states still operate disability-based institutions. Over 10,000 people are still in them. You're going to hear later about some of the cases that involve specifically disabled children being placed in institutions. But again, Section 504 provides that legal defense. But if that legal defense goes away, we don't really know where we are. So in that complaint in February, we found out that, that was reiterated. Those are their 4 issues. It's not merely, one facet. Those are the 4 that they want to strike, and they want the entire law gone. So right now, the update is that the case is stayed, and people are, rejoicing in some sense. Oh my goodness, yay, that means it stopped. No, stayed does not mean stops. Stayed means paused. So we are expecting a brief from both sides to be released on or before April 21st, explaining where the case is right now. And we will see what the outcome of that is. But as our next presenter will connote, it really is going to depend on that one judge and the circuit court potentially above him. So that is what I have to share with you all about Texas v. Becerra or Texas v. Kennedy. And I believe we are taking questions at the end. So I will, if any of you have any, I would be happy to take them. Asalu?
Thank you so much for that information, Kelly. Now, it is important for us to know about the court that will be deciding this case. First, the district court will hear it, and then potentially after that, the circuit court will. We also heard a lot about segregation and institutionalization. So it is important for us to know what cases are pending on that front, even before Kennedy has been decided yet. Ava is going to talk to us a bit about this. She's going to address the court that we are up against, as well as what is happening with segregation and institutionalization already.
All right, thank you so much, Asalu. So good evening, everyone. I'm going to be talking to you about the judge who is on this case. It is Judge James Wesley Hendricks. He was appointed in 2019 and previously served as a state judge and prosecutor before becoming a federal judge in the state of Texas. One of his key rulings was, in regarding discrimination, was the case of Texas versus the Department of Justice regarding the Pregnant Workers Fairness Act, also known as PWFA. This law is designed to protect pregnant workers by requiring employers to provide reasonable accommodations. However, Judge Hendricks ruled in favor of Texas, blocking the enforcement of the PWFA in the state. This decision raises concerns about protections for individuals with disabilities and sends a troubling message about valuing the rights of those who are in need of accommodations. Moving beyond Judge Hendricks, I would like for us to look at some other cases that are still relevant today while we still have the 504 Act in place. So United States versus State of Florida, this involves the rights of individuals with disabilities who were 40 who were institutionalized, and to focus on a particular student, a teenager was denied community outings, exemplifying the issue of segregation. This court ruled in his favor, emphasizing the need to support the community integration, which was only made possible through the 504 Act. This was very unfortunate, though, for the student because many of the outings prior to this being ruled in his favor was him as a teenager only being placed in a preschool classroom throughout the day, which is not an appropriate integration for this age group. Another case I would like to discuss is the Department of Justice versus Georgia. This happened in 2016. The U.S. Department of Justice sued Georgia for unlawful segregation of students with disabilities. This case challenges achieving full integration despite legal protection, showing that over 5,000 children were segregated and left to be without their other peers in a general educational setting. Even knowing this case was only resolved by limiting segregation, it did not completely eliminate it. Something else that I want to talk about, I'm going to give a trigger warning here that this is very disturbing. I do want to mention that there is a school, an institution in Massachusetts today that is still using electric shocks as discipline for individuals with disability. Not only does this practice show serious ethical concerns, but it also shows that we are facing troubles in regarding our legal protections, even with the 504 Act still in place. So why does this matter? This highlights that judges play a crucial role in shaping public policy and protecting civil rights. Judge Hendrick's rulings often spark controversy, leaving many questioning whether he considers the broader impact on people, specifically those with disabilities or individuals of minorities. The Northern District of Texas, where Judge Hendricks presides, has faced criticism for perceived bias or rulings that may negatively impact minority groups. Issues related to voting rights and other civil rights cases have resulted in outcomes that some argue do not fully protect the interests of marginalized communities. The Northern District of Texas the Northern District of Texas also shows that they tend to it challenges the state's treatment to minority voters as well. So the concept of judge and circuit shopping, this is another concern where plaintiffs choose favorable courts, undermining judicial impartiality and affecting fair treatment. In conclusion, Judge James Wesley Hendricks is influential figure whose decisions affect many lives, including ours, in regarding the 504 Act. Thank you, Asla.
Thank you so much, Ava. I would just like to emphasize that the Florida and Georgia case that Ava just talked about are very recent cases. Now, we've shared a lot of information with you guys that might have been hard to hear. But at NABS and as a division of the National Federation for the Blind, know that there is always something we can do to ensure that our rights are protected. Here to talk to us a bit about some next steps we can take to help save Section 504 is a disability rights attorney and educator, Carlton Walker.
Good evening, everyone. It's so great to be able to be here, and thank you, NABS, for inviting me to be here. I am Carlton Walker, and I'm a teacher, a certified teacher of blind students, but I'm also an attorney and parent of a blind child. The suit is a concern, to be sure. Now that it's on hold for a little bit, a lot of people are working behind the scenes, but we can work behind the scenes as well. If you live in, or go to school in, or work in one of the states that is one of the 17. I'm going to list those really quick in just a second. Please consider contacting your attorney general and describing to them what your concerns are. You may be concerned that Section 504 is what allows you to go to school, to work, to live in your state, to be able to pay your taxes, to be able to go to the courthouse and get information, to be able to get a job application and fill it out, to be able to get reasonable accommodations at work that allow you to perform all of the essential portions of the job, and to be able to contribute to your employment team or at school, to be able to do all the essential functions, to fulfill all of the requirements of your classes and degrees. You just need some doors being opened. And that's what 504 does. I want to, I keep up on this, and a lot of things are changing all the time. I'm pointing this out because some of these attorneys general are saying, like I believe Ava had said, oh, no, we didn't mean that, or maybe it was Kaylee, we didn't mean it that way. We mean it this other way. Well, when it first came out, and it still is against HHS, Department of Human Health Services, back when the suit was filed, there was an intact Department of Education, and there were no moves to dismantle it. That has changed, and just in the last 2 days, it has come out in the news that the administration intends to put special education K through 12 in the Department of Health and Human Services. So when we were first talking about this, we in the disability rights legal community knew it was concerning for HHS, but it wasn't a direct concern for Department of Education. Now it is. That's just where we are. So here are the 17 states: Texas, Alaska, Alabama, Arkansas, Florida, Georgia, Indiana, Iowa, Kansas, Louisiana, Missouri, Montana, Nebraska, South Carolina, South Dakota, Utah, and West Virginia. I will make sure that if you don't have this already, we'll make sure that you can have access to this list. The individuals who are pushing the suit forward are state attorneys general. So you could, I do have, I think, a pretty current list of those folks, and I will get that to Haley and Ava. But these are elected officials in most cases in your state. And they can withdraw from the case if we can get them to. We want to reach out to them. We want you to reach out to them, your family, your school professors, your employers and your peers, fellow employees, anybody who knows you, who understands how important just having the right to compete is. And that's all 504 is. It is not changing all the rules. It is a reasonable accommodation. It's an equal opportunity to do something, not getting an equal result. It also is about freedom from discrimination based on your disability. So allowing individuals with service animals or long white canes. We've had students, children, when I was as a parent of blind children, being refused admission into state buildings, into museums, because they have their long white cane with them. 504 protects them. No 504, it's a pretty dismal place to be. And please remind these folks that Section 504 is more than 4 decades old. 5 decades, sorry, more than 5 decades old, more than half a century, 1973, before many of you were born, only 2 years after I was born, and I'm old. So this has been a long-standing law, is part of our fabric as a community, as a nation. And to rip that away will cause bleeding and scarring for years to come, and we can't have that. If you are not in one of the 17 states, I will go through them one more time. Support your friends who are. Ask if there is anything you can do to help, and keep monitoring with NABS and NFB and other groups with which you may be affiliated. We don't necessarily want to stir a hornet's nest where there isn't one. We would like for that number to go down and not up. But I know one of our callers is in Pennsylvania. I'm in Pennsylvania. Families in North Carolina. I'm lucky. Both of my states have stepped away from this. But I'm here to help others who aren't in that good position, so we can support you to get the word out to your attorneys general in the following 17 states: Texas, Alaska, Alabama, Arkansas, Florida, Georgia, Indiana, Iowa, Kansas, Louisiana, Missouri, Montana, Nebraska, South Carolina, South Dakota, Utah, and West Virginia. Thank you for your time and your dedication to our cause.
Thank you so much, Carlton. That was wonderful to hear. I want to emphasize a couple of things you said, because it was really an important point. It is also important to note that Florida and Georgia, one of the two, those are the two part of the states that are suing. They are the ones responsible for institutionalization and segregation policies. So that is also important to note. I would also like to emphasize one last thing. If you are not in the states that are suing, you can support your fellow people with disabilities in those states by reaching out to your state's AG, attorney generals, and writing them a letter saying, please, this is such an important law. Please reach out to your colleagues and talk to, ask them to pull out of the suits. Just wanted to note that. But thank you so much for that, Carlton. So we've shared a lot of information with you that might be hard to hear, but it is always important to know that there's something we can do. So now to wrap things up, we're going to have a question section. So if you have any questions for our guest speakers, please feel free to say your name first, please, and then I will let you know when you can speak. Any questions for any of our speakers?
Sean.
Go ahead, Sean.
Hi. So my understanding is that HHS has also filed a brief agreeing that 504 is not constitutional. So I just wanted to understand, what did they say their reasons are for saying that, or is there any other information you could say about that?
Kaylee?
Go ahead, Kayla.
Yeah, so great question, Sean. So they did submit the brief jointly, so it's kind of difficult to tell who wrote what, if that makes any sense. Like, on the list of authors, all of the 17 attorneys general are there, and the officials from HHS are also there. So it's the same justification, the spendings clause argument, but then they cite specifically in that February brief the 4 prongs that I went over. So 1, the gender dysphoria classification. 2, they think the application of the no discrimination policy is too broad and they want to narrow it. 3, the most integrated setting. They kind of act like that is new, but that's been here for 50 years. And then 4, the protection of disabled people at risk of being placed in institutionalization, and just highlighting that case that Ava talked about, right? That was just ruled in 2022. That was 140 disabled children being placed in institutions without their consent in Florida. And that was one of, as also mentioned, the 17 states suing, right? So to answer your question, those are the 4 reasons that HHS and the 17 states kind of agree on.
Okay, got it. Thank you. Just a really quick follow-up. I just wanted to ask, is it reasonable as an advocate also to reach out to your state's AG if you don't live in that state, to discourage them or to ask them to do something about it?
I
Or is
don't think
there,
it's, yeah, I don't think it's unreasonable at all. I think any kind of intervention, especially if you live, like, I would say do a little bit of background first,
yeah.
and figure out whether, like, I know for me, like, my state's attorney general my entire state's department is really conscious of civil rights. So that's definitely, calls I'm going to be making. But if you are at all concerned, right, like Carlton was saying, we don't want the number of states going up. So do exercise a little bit of discretion and research first, but also reaching out to, to any other officials that you are friendly to the cause could be great. And just generally spreading the word.
Thanks, Kaylee.
Thank you for those questions, Sean. If anyone has any questions, raise your hand and I'll call your name out.
It's Kinnick.
Oh, go ahead, Kinnick.
Yeah, like I'm a high school student. Like, will 504 like not affect me in Kansas?
So 504
Carlton?
affects. Go ahead.
Oh, sorry, Carly. You're in Kansas. Actually, it really affects you a lot. I hear where you're coming from. You're probably thinking, and a lot of folks think this, in K through 12 for college, I either have an IEP or a 504 plan.
Yeah,
That's
like
true. And you have an IEP plan.
Yeah, I do.
But here's the little secret, and it's been coming to, because I'm a nerd, a law nerd, and there have been some cases that have been coming down in 2017 and 2023 that actually the Supreme Court has been, I think, finding things the right way. And they're saying that 504 still protects us, even if we have an IEP. And this is because, and there's some good information from the Department of Education that says it too, because IEPs are that whole team thing, and they can be they're individualized, but sometimes IEP teams will individualize a student out of the regular education. I see it a lot when kids are especially younger, and if they have some vision, well, you can just use large print. And then when that doesn't work anymore, you'll just use audio. It's all great. And completely ignoring the IEP right to Braille, but also sometimes they set things up, they try to make us seem really other, and it's not as integrated. They don't provide the effective communication. They'll say, well, you can have an audio thing and maybe we'll get Braille, we'll get Braille when possible, and that kind of jazz. Really, 504 and the Americans with Disabilities Act can protect students even who have an IEP plan. So 504 is really important in school for you. It still can be important. And outside of school, it's always important too. Because 504 is what provides summer camps, extracurriculars, anything like that that the school is doing or involved in your state. So 504 helps you outside the school building all the time, but can actually help you inside the school building too.
So what's gonna happen in Kansas, since I'm a high schooler?
Kinnick, I'm so sorry to cut you off, but we want to get everyone to ask their questions too. You can stay for the discussion section if you have any further questions.
Let me just say that these are the states pushing it, but whatever happens with this case will happen to the whole country. Either keeping 504 or not, it won't be action specific to any of the 17 states. It will affect all 50 states.
Okay.
Thank you so much, Carlton, for fielding that question. Preston, I believe your hand is up. No?
Hello, excuse me. Hello, everyone. I know I'm not a student, but I feel I sit in to learn more about this pressing issue, if you will. So I guess what I want to know is, do you think a lot of attorney generals and senators in the states that aren't affected, like here in PA, do you think they'll take action on this pressing issue? Because I know we have 17 to deal with.
So from my experience, and Carlton, feel free to jump in too, no one really knows about this. I know I've specifically talked to congressional offices in a few cases, and really no one seems to know that this is happening.
Right.
I've talked to many governmental agencies, and there just seems to be a very startling lack of awareness. I think it can even be seen in the fact that this case was initially filed in September, but there really wasn't a public outcry until late January, early February. I know personally, I didn't really see the wave of social media awareness of it until that time. So
Yeah, me neither.
I don't know if any action is being taken yet, because it does seem like there's a general lack of awareness of it.
Right.
Carlton, yeah, I agree. And I honestly think part of it is because it was initially filed, it was focused on HHS, Health and Human Services. And so while 504 is important there, don't get me wrong, it's not, we tend to be looking at the labor and education in we just do. So I think that may be why, and that's the same with other disability organizations across the country. It was definitely on the low burner with everybody else. So, and it still was even after the administration changed. But I do believe personally, I believe now that it's going to get more high profile, and I think we can make it more high profile by showing that a lot of education matters are now going to be at HHS, Health and Human Services. So it's in our ball court completely.
Yes, I fully agree. And, the way I see it, as long as we keep spreading the light and being aware about what's happening, we're able to take action and help our fellow communities. That's the way I see it. So,
Yes.
yeah.
Thank you so much for those questions, Preston. Thank you, Kaylee and Carlton, for fielding those.
Thank you.
We're gonna do one last question. Aaron, do you still have a question?
Yeah, you had mentioned how we don't want the number to go up. But has there been any other states that want to join the 17? And I know you said we don't want it to go up, but has there been anything like that in the other states thinking about joining the 17?
I've been watching the docket very carefully, and Carlton, again, you can feel free to corroborate, but I have not seen any movement. The only movement that we've seen, right, is the defendant, in this case, HHS, agreeing with the claims of the 17 states. So that was kind of the major movement, is that the plaintiffs, the 17 states, they think this way about 504 and they think it needs to be struck down. And now the defendant, the Department of Health and Human Services, agrees that needs to get struck down. But I've not seen any additional states joining this case.
I guess like a real quick one on what about the opposite way then? Any of the 17 states looking to drop out of it?
So yeah, that's the sad part, is there have been a few that have kind of promised constituents that they would drop and then not dropped. So we have seen a few instances of that, but no one's dropped.
All right, yeah, thanks for answering my question.
Okay. Thank you so much, Kaylee, for answering that. And then thank you for your question, Aaron. Any further comments or questions, we can have a discussion. We have a discussion section after. So please feel free to stay for that. Okay, we would like to end by just sharing with you a couple resources that can help you stay more informed on this case. First, we have the Bisalon Center for Mental Health Law. They have released a summary on their website that goes over what this case is and what's what is happening. So that's on their website, and we will link that in the chat below. Secondly, the ARC has released an article about this case that is really simplified and easier to understand. So we'll also put that in the chat. Last but certainly not least, the NFB has released a copy of the letter they sent to the 17 states. So you can use that as inspiration if you wish to write one as well. Okay, so we will be ending the recording for this call here, but we will then open the floor up to discussion on what we've heard tonight. If you need to leave, absolutely feel free to do that. You can do so now, but if you would like to stay and share any thoughts, concerns, feedback,